Hi, I'm Todd Cox, Associate Director Counsel of the Legal Defense Fund. Thank you for your service to this country. You are the descendants, guardians, and successors of a rich history of Black federal workers who helped build this country into the powerhouse it is today. The Legal Defense Fund created this webinar to ensure you know your rights. As the administration makes drastic, uninformed cuts to the federal workforce, this moment is undoubtedly one of extreme uncertainty and distress. And yet, targeting Black people's opportunities for upward mobility isn't a new tactic. Since its founding, America has erected countless legal and social hurdles to dampen our prosperity and stop us from thriving. Yet, we have relentlessly persisted and succeeded. And one of the many pathways we've pursued to achieve this success are federal jobs, which have historically offered Black people the reliable rights protections and economic stability sometimes missing from other opportunities. Make no mistake, an attack on federal jobs is an attack on Black people. It's a tactic from an age-old playbook meant to disempower us and hamper our prosperity. These tactics have never stopped us before, and they won't stop us now. But we don't succeed by grit alone. Now, more than ever, we must work together and use all available tools and resources to safeguard our rights and continued prosperity. At the Legal Defense Fund, we have, for 85 years and counting, used bold legal strategies, tenacious advocacy, and strategic, thoughtful coalition building to defend the full dignity and citizenship of Black people in America. We were built for this, and together we will move forward and thrive. Knowledge precedes action, so please listen in and know your rights. Thank you for trusting the Legal Defense Fund with your time and attention.
Thank you for that introduction. My name is Jennifer Holmes, and I'm Deputy Director of Litigation at the Legal Defense Fund. Today, my colleagues and I will provide a brief overview about the makeup of the federal workforce, then touch on the collection of rights and protections that federal workers have, address some questions that have come up about the Trump administration's actions against the federal workforce, and finally, share additional resources. The federal government is the United States' largest employer, employing more than 2 million people. 20% of all federal workers live in the DC metro area, but the majority of federal workers are located outside of DC, residing in every state and territory in the country. The federal government employs a highly diverse workforce where 40% of federal workers identify as persons of color, and it was historically an employer where Black people experienced greater equality and opportunity compared to the private sector. Black people comprise nearly 19% of the federal workforce, which is a larger share than their participation in the private sector and larger than their proportion of the overall population. Turning to the agency level, the Veteran Affairs Department is the largest employer among all federal agencies, employing roughly 21% of the federal workforce, and around 25% of the VA workforce is Black. The 5 federal agencies with the largest percentages of Black employees are Housing and Urban Development, the Department of Education, the Small Business Administration, the Social Security Administration, and the Treasury Department. As you may know, some of these agencies have been particular targets of this administration's executive actions. So while we recognize that many federal workers are under siege right now, we know that the attacks on the rights and livelihoods of federal workers have an acute impact on Black workers. And we hope today's webinar can provide information about the rights of federal workers and resources they can turn to as they navigate this tumultuous time, no matter their background. We recognize that the landscape is rapidly changing, and some actions of the administration are targeting the very mechanisms and offices in government that were put in place to protect federal workers. But that doesn't mean that employees' rights have changed. Those rights are enshrined in statutes, regulations, and collective bargaining agreements, as my legal colleagues will discuss shortly. Finally, a reminder, this webinar is meant to provide information, not legal advice. Please seek out a qualified attorney if you need legal advice on your specific circumstances. With that, I would like to turn the floor over to my colleague, Molly Kane.
Thank you, Jennifer. Good afternoon, all. My name is Molly Kane, and I'm an assistant counsel at the Legal Defense Fund. Today, I will be speaking about two topics. The first is the federal workers' rights to be free from discrimination on the basis of protected characteristics, and the second is federal workers' freedom of speech rights. So first, let's talk about the federal laws that give federal workers the right to be free from discrimination. There are a variety of federal laws that protect federal workers and job applicants to federal jobs from discrimination. The first I would like to talk about today is Title VII. So the Civil Rights Act of 1964 is still the law of the land, and its Title VII provision protects all workers, including federal workers, from discrimination in hiring, firing, pay, job assignments, and benefits on the basis of an employee or job applicant's race, color, religion, sex, sexual orientation, gender identity, and national origin. Title VII also protects federal employees from harassment because of these protected characteristics. For example, according to the EEOC, harassment based on an employee's color can include racial slurs, offensive or derogatory remarks about a person's race or color, or the display of racially offensive symbols. And finally, an employment policy or practice that applies to all federal workers, regardless of race or color, can still be prohibited by Title VII if it has a negative impact on the employment of people of a particular race or color and is not job-related or necessary to the operation of the business. The next law is the Age Discrimination Employment Act, known as the ADEA, which protects federal workers from age discrimination for workers who are 40 years or older. And then there is the Rehabilitation Act, which protects federal workers from discrimination based on disability. And as a final example, the Genetic Information Non-Discrimination Act, or GINA, protects against discrimination based on genetic information. And also, federal law protects federal workers, job applicants, and former federal workers from retaliation, aka punishment, for filing a charge or complaint of discrimination, participating in a discrimination investigation or lawsuit, or opposing discrimination. An example of opposing discrimination is threatening to file a charge or complaint of discrimination. Federal workers are protected from retaliation if they do that. And I want to finish this section by flagging that federal workers usually need to participate in an administrative process to seek remedies for discrimination. Federal workers seeking to remedy discrimination they are experiencing generally must report any incidents of discrimination to their employer's Equal Employment Opportunity Officer, or EEO officer, within 45 days. Dates are important to this process, so federal employees may need to act quickly. And then after the initial report is filed, an employee generally will need to file an administrative complaint with the Equal Employment Opportunity Commission, or EEOC, and wait a period of time before a Title VII lawsuit can be filed in court. Next, I'm going to talk about the First Amendment. The First Amendment gives citizens constitutional rights to the freedom of speech, association, press, and religion that protect them from government and/or state actions that curtail those rights. The First Amendment also protects citizens from being retaliated against by the government for exercising their First Amendment rights. However, First Amendment rights for federal employees can be more limited when federal workers are at work and the government is acting as their employer. In this context, the government may limit the speech of its employees in instances where that speech could impact their work responsibilities. This is especially true if a federal worker is a high-level employee or a political appointee, or if the federal worker is not speaking about a matter of public concern, or if the federal worker's speech is a part of their normal job duties. In those instances, federal workers have limited First Amendment speech protections. A federal worker's First Amendment rights are at their strongest when the federal worker is speaking or associating with others in their personal capacity, which means outside the workplace and off official devices or channels. The contours of First Amendment speech rights for federal employees are complicated and very fact-specific, and I want to flag that there are specific whistleblower protections for certain speech that my colleague Madrian will discuss in the next section right after me. So to help, we've included a QR code to a chart from the ACLU of DC that can help federal workers walk through to help determine if the First Amendment applies to their situation. And finally, I want to flag that the Hatch Act and agency-specific rules may also place limits on federal employees' political activity. The Hatch Act is a federal law that limits certain political activities. The law's purposes are to ensure that the federal programs are administered in a way that is nonpartisan, which protects federal employees from political coercion in the workplace, and ensures that federal employees are advanced based on merit and not based on political affiliation. So except for the president and vice president, all federal civilian executive branch employees are covered by the Hatch Act, including employees of the U.S. Postal Service. And even part-time employees are covered by the Hatch Act, and all employees continue to be covered while they are on annual leave, sick leave, leave without pay, or furlough. And so that's it for me. Thank you all for your time. And I will now turn the presentation over to my colleague, Madrian, who will discuss protections for whistleblowers.
Thanks so much, Molly. My name is Madrian Lowe, and I'm a legal fellow here at LDF. And I'm going to be speaking to everyone about whistleblower protection and what protections exist for people who think they may fall into this category of folks. For starters, let's talk about what whistleblowers are. So whistleblowers are people who witness wrongdoing in the workplace and decide to speak up and expose these serious violations of public trust. The generally accepted definition that's codified into law by the Whistleblower Protection Act applies to most federal employees and defines whistleblowers as an employee who discloses information that they reasonably believe evidences a violation of law, rule, or regulation, gross mismanagement or gross waste of funds, an abuse of authority, or a substantial and specific danger to public health and safety. Again, this is a generally accepted definition. It's important to think about this in framing how serious allegations are required to be in order to amount to whistleblowing activity. An employee is concerned that about a disclosure or concerned about something that may not amount to this type of legal violation may not be protected under the Whistleblower Protection Act, but that doesn't mean that a federal employee will be completely prohibited from discussing per se, because as Molly discussed previously, you may be covered under some First Amendment protections. Also, I want to talk about what law protects whistleblowers. So as previously mentioned, the Whistleblower Protection Act is what gives most federal employees the right to disclose information both internally, which includes co-workers, managers, organizational hotlines, and internal agencies, inspector generals, as well as externally to places like Congress, regulators, the media, and watchdog organizations, and more. Next, I want to talk about the protected disclosures and unprotected disclosures. So protected disclosure. So the important language here is the reasonable belief language. This means that employees don't have to have evidence of a disclosure. Of course, evidence will bolster claims, but protected disclosures are generally a disclosure is protected when an employee is maybe mistaken about the concerns, but has a reasonable belief that the disclosure evidences serious wrongdoing. If the disclosure is made in writing or orally, if the disclosure is made to a supervisor or a person who participated in the wrongdoing, if it reveals information that was previously disclosed, and it doesn't matter what the employee's motives are for making the disclosure, nor does it matter if the employee was off duty or if it concerns something that happened in the past. Now, whistleblowers can make disclosures anonymously, but this may make it harder to prove a retaliation claim, so that's something to consider when thinking about whether or not to disclose anonymously or make the claim known as yourself. And it's also, again, I just want to harp on the fact that the operative language here is the reasonable belief part. And unprotected disclosures includes things that maybe like a disagreement about policy or decision that is not otherwise unlawful or does not constitute this type of gross mismanagement. And additionally, things that are not going to be covered or protected are things like executive order mandates that require information to be kept secret in the interest of national defense or foreign affairs. Things like the Trade Act, Trade Secrets Act, or the Privacy Act, those things are not going to be protected disclosures. However, duty speech is protected. So this means that people who have some sort of statutory requirement within their job to make sure that things are being investigated properly or disclosing wrongdoing, those things are still going to be protected by the Whistleblower Protection Enhancement Act, meaning that these concerns about illegality or gross mismanagement will still be protected even if it's one's job to report those types of things anyway. Okay, next slide, please. So responses to whistleblowing can vary, and it's important that federal workers are protected from adverse action. The Whistleblower Protection Act prohibits employers from taking, failing to take, or threatening to take personnel actions against employees because of whistleblowing activity. And it covers a lot of things that we have referenced in the Whistleblower Protection Resource Guide here on this QR code. But some examples include a promotion or failure to promote, disciplinary or corrective action, gag orders, or changes in duties, responsibilities, or working conditions. Now, federal employees who have experienced any prohibited action as a result of a disclosure, participation in an investigation, involving the Office of the Inspector General, Office of Special Counsel, or another law enforcement office or Congress, or refusal to disobey a law can file a reprisal claim. Now, federal employees have the option to file this claim with the Office of Special Counsel, the Office of the Inspector General for their agency, with their union rep, or with the Office of the MSPB board. It's important to know that the Office of the Inspector General, however, does not have the corrective enforcement power. They can only make suggested actions to the relevant agency. So federal employees want to consider all of the options and think about these things and talk through these types of processes with their union rep and their lawyers before making these types of decisions. Again, I want to reference the Whistleblower Protection Resource Guide that we have referenced here, and also LDF's 5 Things Federal Workers Should Know worksheet. And at this time, I'm going to pass it over to Jennifer, who's going to be discussing civil service protections.
Thank you, Madrian. I'm going to provide an overview of the framework of civil service protections. The vast majority of federal employees are career civil servants who are accorded certain employment protections, including removal protections and competitive hiring guarantees as part of the federal civil service. The purpose of these protections is to create a core of experts with job security that allows them to do their jobs in an apolitical manner and work across various administrations to serve the American people, free from corruption and improper influence. Civil service protections were largely established by the Civil Service Reform Act of 1978. This is codified in Title V of the U.S. Code, and the most relevant chapter for our purposes is Chapter 75, which covers adverse actions. Civil service protections vary depending on an employee's position, classification, and tenure, so it's important to know how an employee is categorized. About 2/3 of the federal workforce falls within the competitive service. This group of employees has full civil service protections under the law. A large minority of federal employees is part of the accepted service. They have some, but not all, civil service protections. The accepted service is categorized into schedules that each have their own requirements or protections. Positions on schedules A, B, D, and E have similar appeal rights and removal protections as the competitive service. But Schedule C, accepted service, covers many political positions, which generally do not have those civil service protections. Next, we have the senior executive service. This covers a small number of management level officials, both career and political positions, and it is a different classification from the competitive service and from the accepted service. Finally, there's a category called probationary employees. This is a separate scheme that covers employees with a short tenure in government, usually less than 1 or 2 years. Probationary employees have a much more limited civil service protections and generally do not have appeal rights. But probationary status may be impacted by whether an employee is preference eligible, for example, due to their veteran status, or may have prior government service that could be counted towards their probationary period. So it's very important for probationary employees to know whether they have been correctly classified as probationary in any action taken against them. Turning briefly to the substance of civil service protections, they generally include advance notice requirements before an employee can be fired or reassigned, and in some cases, the right to challenge or appeal adverse employment decisions. Another important source of rights are collective bargaining agreements negotiated between unions and the federal government. These may offer additional rights on top of civil service protections to covered employees. So just to reiterate, it's important for all federal workers to know their status. It's critical to know how you're categorized as a federal worker so you can know what rights and protections you may have. A place you can find this information is the SF50 form, an image of which is shown on this slide. And this form is contained in an employee's personnel file and will list the employee's status as well as their bargaining unit status, which indicates whether the employee is covered by a collective bargaining agreement. I'm going to now turn the presentation over to Rob Shriver. Rob is the Managing Director of Civil Service Strong at Democracy Forward, and prior to January 20th, he was the Acting Director of the Office of Personnel Management. He has a wealth of knowledge on this information, and we are lucky to have him with us today.
Thank you, Jennifer. I'm going to spend a few minutes going over the executive orders that have been issued during the first 6-7 weeks of the Trump administration affecting federal workers. You can see a summary of them here on this slide. I'm just going to voice over some highlights of a few of them. First, of course, there is the orders directing federal workers to return to in-person work. Generally speaking, that means going into the office 5 days a week. That's a major change from a decades-long policy affecting federal workers. Telework has been around in the federal government for many years now, including prior to the pandemic. And so a return to full-time in-person work is a pretty dramatic change. Also, there was an executive order freezing regulations pending review. This is more of a typical executive order that occurs at the beginning of a new administration. They will freeze any regulatory actions that have not been completed and evaluate them based on their new priorities. So that is something that is underway. The administration implemented a broad-based hiring freeze from the very first week. And it has authorized a few exceptions to that hiring freeze in subsequent weeks. But generally speaking, federal agencies are prohibited from hiring, including from backfilling positions. There is a reinstitution of what was called Schedule F during the first Trump administration. It's now called Schedule Policy Career. This is a technical HR mechanism that shifts potentially tens of thousands of federal workers from career type jobs into jobs that are more like those Schedule C political type positions that we talked about earlier in the session. There was an executive order on restoring accountability for career senior executives. Really what this does is introduce a higher level of politicization into the career SES, including in the hiring and performance management responsibilities. What the order does is require that there be more political SES than career SES in both the ERB, which is the board that's used to evaluate and approve senior executive hiring, and the PRB, the Performance Review Board, which agencies use to evaluate the performance of career senior executives. Of course, there was an executive order establishing and implementing the President's Department of Government Efficiency. DOGE has been housed within what was formerly the U.S. Digital Service at OMB. It's now called the U.S. DOGE Service. And DOGE, as many of you probably have followed, has been appearing at multiple departments and agencies across government, seizing data and being sort of the leading force behind these workforce policies of the new administration. There was an executive order on ending what they called radical and wasteful government DEI programs and preferencing. This executive order has led to the widespread reduction in force of people who work on DEI or who used to work on DEI or who maybe took a training in DEI or who maybe participated as part of their collateral duties on a DEI work group. So the administration has taken a very broad view of which federal workers should essentially be penalized for having worked or participated in some way on DEI programs. There is executive action on reforming the federal hiring process and restoring merit to government service. The title here is somewhat ironic given everything that the administration is doing to undermine merit in the federal hiring process. Essentially, this is more about DEI and more about speeding up the time to hire whenever federal agencies are allowed to get back to hiring people for their vacancies. There has been executive action on implementing the President's Department of Government Efficiency Workforce Optimization Initiative, and there's recently been more guidance about this. This is the direction from the administration for agencies to look for ways to consolidate functions, eliminate functions, shrink their footprint for the buildings that they occupy, and conduct wide-scale reductions in force to, again, reduce the size of the federal workforce. And then related to that is the commencing the reduction of the federal bureaucracy. Again, the administration has put out guidance, most recently through an OMB OPM memo to agencies about the activities they should be undertaking to plan for massive reductions of the federal workforce and the way that they should prioritize those activities. All of this adds up to an overall strategy to drive out career federal workers from across the government. And really, these executive actions are just sort of the tip of the iceberg. There have been other mechanisms, such as shuttering the USAID agency, shuttering the Consumer Financial Protection Bureau, and more like that. So all of it is part of this broader theme of reducing the size of the federal workforce. Let's go ahead and move on to, I think we have some Q&As coming up next, right? Okay. I think several of these have come in beforehand. I'm going to try to address them the best that I can. So we just talked about all of the different actions that the administration is taking to try to shrink the federal workforce and drive federal workers to resign their position or to be laid off through reductions in force. And this first question is about what are the rights for a federal worker to appeal their termination. There's not a simple answer to this because there's potentially a lot of different rights and they might depend on the type of federal employee you are. So generally speaking, most federal employees who are terminated, that is considered an adverse action, and you have adverse action appeal rights under Chapter 75 of Title V of the U.S. Code. In order to take advantage of those appeal rights, you have to meet the definition of an employee, which often means you are past your probationary or trial period. If you meet that definition of an employee and you are terminated, you have the right to appeal to the Merit System Protection Board. If you are a member of a bargaining unit, you also may have the ability to appeal that termination through the negotiated grievance process under your collective bargaining agreement. The next question is, do changes in the Merit Systems Protection Board composition affect the appeals process for federal workers? So I think what this question is getting at is that the president attempted to fire one of the Merit System Protection Board members by court order. She was reinstated into her position, but in the meantime, another MSPB member came to the end of his term and has now retired. So the Merit System Protection Board currently has 2 members. That constitutes a quorum. The MSPB is able to act with 2 members while they await the appointment and confirmation of a 3rd member. And even in the absence of a quorum, the Merit System Protection Board relies on administrative judges to hear most employee appeals in the first instance. So even in the absence of a quorum, your appeal can be heard by an MSPB administrative judge. Let's move to the next slide, please, for more questions. Okay, what are the rights of probationary employees who have been terminated? So you may recall that when I answered the first question, I specifically talked about how probationary employees generally do not have the same appeal rights to the Merit System Protection Board as those who have completed their probationary period. There are exceptions for that. Probationary employees who believe they have been terminated based on political affiliation or marital status do have the ability to file an appeal directly with the Merit System Protection Board. If you are a member of a bargaining unit, again, you should check in with your union representative because probationary employees may have rights under the contract through the negotiated grievance process to challenge their termination. And then finally, individuals who are subjected to prohibited personnel practices, whether you're an applicant, a probationary employee, or an employee who has completed your probationary period, you are able to file a complaint with the Office of Special Counsel. My organization, Democracy Forward, working with the Alden Law Group, has in fact filed a complaint with the Office of Special Counsel on behalf of probationary employees, alleging that the mass termination across the government constitutes a variety of prohibited personnel practices. When you go to the Office of Special Counsel, they have the ability to conduct an investigation into these allegations of a prohibited personnel practice. That typically lasts about 45 days. And then they have the opportunity to seek corrective action for the Merit System Protection Board, which can include reinstatement and payment of back pay. What are the rights of probationary employees who remain in federal employment? Well, your right is to be treated with dignity and respect and to be evaluated based on your own performance. So the problem that we see with the mass terminations of probationary employees is that those terminations are not based on an individual assessment of each individual employee's performance. And that if in fact an agency was evaluating the performance of probationary employees, the vast majority would be able to continue in their position. So you have that right to be evaluated based on your individual performance. In addition, if your agency is going to conduct a reduction in force, they need to follow the rules to do that. You can't just do a mass termination of probationary employees as part of a RIF. Probationary employees would actually be included in the RIF process, and the agency would have to provide notice and follow all of the rules that apply to a reduction of force, even for probationary employees. Let's move to the next slide, please. Okay, this is a question for folks who are not in a collective bargaining agreement, not in a bargaining unit, and therefore not governed by a collective bargaining agreement. What are the rights of non-collective bargaining employees, including those who are ineligible by virtue of their position? So about half the federal government is not eligible to be in a labor union. So there are lots of federal employees who aren't covered by collective bargaining agreements. The remedies that apply to you are several of the remedies that we have already discussed. Individuals have the right to appeal adverse actions to the Merit System Protections Board if you meet the definition of an employee. That means if you essentially are beyond your probationary period. You can go and file those appeals with the Merit System Protection Board. You can file complaints with the Office of Special Counsel for prohibited personnel practices. You have rights under the RIF procedures, under OPM's regulations, and if the agency violates your rights or fails to comply with those regulations, again, you can seek a remedy through the appeal mechanism with the Merit System Protection Board. So basically, all of the remedies that we've already discussed, other than those that would be available under the negotiated grievance process, they apply to non-bargaining unit employees as well. And again, we talked earlier in the session about whistleblower protections, EEO rights. All of those rights apply whether you're in a union or not. A question about reasonable accommodations for people with disabilities. Can reasonable accommodations in employment be denied as part of any downsizing and/or requirement to end telework? The short answer is no. Agencies have an obligation to accommodate otherwise qualified individuals with disabilities, so long as those accommodations are reasonable. So employees who have been granted accommodations as part of their job they have a right to keep them, even if there is downsizing going on at the agency or if there is a requirement to end telework. So in other words, if your agency is requiring everybody to return to the office 5 days a week, but you have a reasonable accommodation that allows for you to do your work from home because of a disability, that accommodation continues to be enforceable. If the agency reevaluates and says that that accommodation is no longer a reasonable accommodation, you have the ability to challenge that decision through your agency EEO process, up to and including proceeding with the EEOC. Next slide, please. Benefits. How does a reduction in force or deferred resignation affect federal or other benefits like the thrift savings plan, health insurance, and unemployment benefits? So with respect to a reduction of force, that is an involuntary action where you lose your federal employment because the agency is shrinking the size of its workforce. In that case, once your end date comes and you're no longer a federal employee, your federal health insurance will continue for another 30 days. And then you have the option to enroll in a program called temporary continuation of coverage. That would allow you to maintain your FEHB coverage for another several months. But the catch is that under TCC, you have to pay the full amount of your health insurance premium. So that, in other words, there will no longer be an agency contribution to your health insurance premium. Once you're in TCC, you have to pay the full amount. So again, you get that 30 days after your end date, and then there's the ability to enroll in TCC if you pay the full amount. With respect to thrift savings plan, you keep your thrift savings plan, but your ability to contribute to it would end with the end of your federal employment. With respect to unemployment benefits, just note that that is administered on a state-by-state basis. And so you'd have to check with your state law on the impact on unemployment benefits. Generally speaking, if your job loss is involuntary, such as in a reduction in force, then you're able to collect unemployment benefits. For those who accepted the deferred resignation fork in the road agreement, I think it's really important to check in with your state on whether you would be eligible to collect unemployment benefits at the end of that program when administrative leave comes to an end. Next slide, please. Whistleblowers. With recent firings of inspectors general across agencies, can federal workers still whistleblow to these offices and officers? The answer is yes. There are acting inspectors general in place. They continue to have a statutory responsibility to combat waste, fraud, and abuse. And so your OIG is still a vehicle through which you can raise these concerns. There are also other mechanisms, such as making a protective disclosure to the Office of Special Counsel or connecting with a member of Congress. All right, thank you very much.
Thank you, Rob, and to all of our colleagues. My name is Anusha Thate, and I'm a senior counsel here at LDF. And we know that was a lot of information, and I'm sure you still have many questions given how quickly things are developing and changing. And so what we'd like to do to close out our session is to share some other potential resources that might be helpful to federal workers. And these resources are growing by the day. As explained at the outset, this webinar is, of course, an informational session only. So just to reiterate, none of the presenters today or our organizations are here in a position to provide legal advice. But for any federal workers who are seeking assistance, everyone, of course, has the full right to seek legal counsel or consult with a union representative where applicable if they want to do so. And so while we are not in a position to provide specific referrals for any particular attorneys or law firms, many organizations are putting together resources that might be helpful. A few of them are, and this just scratches the surface, very frankly, but are on this slide here. The first one we want to shout out, of course, is Civil Service Strong, of which Rob is the managing director, and it is a really tremendous set of resources. It's being continually updated with fact sheets, analyses, and updates. Really encourage you to review that website and check back at it. Furthermore, there's also the Partnership for Public Service. Again, another really tremendous resource library. And they're also putting on various webinars, I think, on a weekly basis right now. Dear Civil Servant is another robust resource hub put together by the Protect Democracy organization. And they also have a newsletter, I think, that issues on a weekly basis that you can sign up for. Furthermore, the Public Service Alliance is a newly launched organization that is working to provide resources for federal workers across government. And on this website, there is a form to potentially be connected to a legal referral network. Finally, for DOJ employees specifically, there's an organization that's also been launched in the last couple of months called the Justice Connection. And that organization is providing both information and may also have resources as to potential legal representation. And for folks, of course, can also find relevant information on union websites where that's applicable. And we also want to share that LDF itself has put together various resources that are available on our website. We have 5 Rights of Federal Workers, which is a brief explainer. Secondly, we have the Equal Protection Initiative here at LDF, which is specifically focused on issues pertinent to ensuring the guarantees of equal protection clause and its enshrinement in the Constitution. Finally, our Thurgood Marshall Project has put out a Project 2025 report, what Project 2025 means for Black communities. And as to whistleblower resources, the Government Accountability Project, which Majorian spoke to earlier, is a longstanding organization that supports government whistleblowers. And here also listed, we've included 2 litigation trackers that these organizations are doing tremendous work in keeping updated as litigation developments unfold. So again, all of these are here for you to view and then also listed on LDF's website for future reference. And Jenny, what I'll do is I'll pass it out to you to close us out.
Thank you so much, Anuja, and thank you to all my LDF colleagues, and a special thank you to Rob for joining this webinar today. Just to close things out, I want to say that the Legal Defense Fund, and I know I also speak for Democracy Forward, Rob's organization, we are taking these attacks on the federal workforce very seriously. This is an unprecedented assault on our civil servants and the important work that they do. And we are trying to put together resources as well as legal action that can help turn back this assault. As Anuja mentioned, LDF's website contains a lot of these resources, as does civilservicestrong.org. And we also encourage you, if you are a civil servant associated with an affinity group, we're interested in connecting with you to hear what's going on in government so we can gather information that will help us in our fight to turn back these attacks on our civil servants. So thanks again for being with us today.